the California Supreme Court was quick to jump on and jump on this opening from the U.S. Supreme Court in the Viking River Cruises case. And they issued the decision here in July of 2023. And the California Supreme Court reviewed the issue of whether the employee who has been compelled to arbitrate his or her individual claims under an arbitration agreement with their employer still has statutory standing to pursue any non-individual PAGA claims arising out of events involving other employees in court. So it gets a little confusing, and we don't want to get too much into the weeds, but the employee can bring an individual PAGA case, and they can bring a PAGA case on behalf of other individuals. They actually don't have to even suffer the violation to bring a claim on behalf of other employees for other violations. So sometimes it's referred to as representative action, but that term's got some confusion around it. So we generally refer to that as the non-individual claims under PAGA, or PAGA non-individual claims. And that's really where those penalties add up. PAGAs, when they're bringing, one plaintiff can just bring one case. They don't have to have these other employees opt into the PAGA case. They could just pursue the case, and those penalties add up per employee per pay period. And it's my prior example showed it adds up pretty quickly. So here in Adolph, the California Supreme Court said that even though the employees may be required to arbitrate their individual claims, they can still potentially continue with a PAGA claim on behalf of other employees. The California Supreme Court explained the standing to bring a PAGA claim is very broad, and you have to be an aggrieved employee, and PAGA defines that as someone who, one, has been employed by the employer, the alleged violator, and two, someone against whom one or more of the alleged violations was committed. And as I mentioned before, they only had to have one violation to bring a PAGA action on behalf of all employees, even for other violations that they haven't even suffered, as long as they've had one violation against them. The California Supreme Court's read the standing requirement very broad and very easy to meet. There's another case, Kim versus Raines International, where the plaintiff settled a case, dismissed his individual claims for damages, and the court said that the plaintiff still had standing to proceed with his PAGA claims on behalf of other employees, even though they dismissed their individual claim. And the court continued to explain that PAGA does not require the plaintiff to have an ongoing injury, and has even cited some other cases here in the Adolph case. There was another case recently that held the employee didn't even have to have a violation within the statute of limitations period. It could extend back even further. So they've been reading these claims and standing very broadly. The California Supreme Court's continued to read it broadly. So they're allowing the employees to continue with these cases, even if they have an arbitration agreement that says they can't bring any claims in arbitration on behalf of other employees.